and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
David Whiting, Melbourne solicitor, is one of the best, and he's here to help you with your legal quandaries. 1300 222 774 is my number. He's sitting at an oak desk in a velvet-lined office somewhere in a leafy suburb, quietly and calmly in Melbourne. David Whiting, good morning.
Good morning, Virginia, but you forgot the smoking jacket and the cravat.
Smoking jacket, cravat, I'm sorry, leather slippers.
Yes.
If only there was a pipe, but I know that you're a non-smoker.
I am.
How are you, David?
I am very well, thank you.
You're managing to...
I'm looking forward to the detail. I'm managing, but I'm looking forward to the detail of the regulations that follow the press releases from the Premier. So hopefully that will turn up sometime today.
In relation to what, though?
I'm kind of like socialisation is interesting. Because of what I do, you actually do get to engage with a lot of people, most of them in Zoom meetings. But to be able to have family over would be really very nice.
Yes, it would be nice. I think we all hit the phones, and I must admit I did the moment I heard that news yesterday and said, "Come on over."
Okay.
But
not till tomorrow night.
That's right. No, Friday night is when we will do that. We've got some homework from last week. This concerns Anna from St Kilda. What was she on about?
She had a small family therapy practice that she ran from one room. As a result of the social distancing requirements, her business just died. So she has no business, and she was unable to reach a deal with the landlord on rent. So she's closed her practice and wants to bring the lease to an end. And so the question was, do the COVID-19 rules that came into effect on the 13th of April give her that option? And the answer is no. Right. But the guideline from the state government is that there ought to be a rental payment waiver or a deferral proportionate to the income reduction. And in her case, the income reduction is 100%. So in the event that she can't reach an agreement, and the recommendation is that you put a proposal to the landlord and negotiate. If you can't get what you want there, or you can't reach a deal, you then go to the Victorian Small Business Commissioner, who will organise a mediation. And if the mediation doesn't succeed, then you go to VCAT.
Right.
And VCAT will determine what an appropriate outcome would be in terms of rent reduction or deferral. So Anna should not give up, given that her business is closed. The only way she can move from where she is now is to improve her net financial position. So negotiate in writing. Don't get out that outcome, Small Business Commissioner. Don't get that outcome, go to VCAT.
I hope you're listening this morning, Anna, and I hope that's useful. I also want to jump to some other issues that you've just raised here with us before we get to our calls. And that is that an executor can be personally liable for a mismanaged case.
Yes, there was an interesting case reported yesterday in the Victorian Supreme Court. And in the situation, there was criticism by the court of the executor and of the executor's lawyer. Because it was a small estate, costs were quite high, there were some offers made, and at the usual expectation from an executor is that the executor is supposed to be dispassionate and rational, even if the executor has an interest in the estate. In this particular case, it would appear that the executor was also a beneficiary, and whatever was lost in the claim against the estate was going to affect the executor's share of the estate. So at the end of the day, the executor ended up with the worst possible outcome.
Right.
And the executor was required to pay her own costs, and the executor was required to pay all of the plaintiff's costs. And in circumstances where she was not able to recover any money from the estate. So it's a salutary lesson. The expectation is that as the executor was supposed to be wise and just, the testator is supposed to be wise and just and sometimes fails, the executor has an obligation to do what's in the best interest of the of the estate and make perfectly rational decisions.
And it's not uncommon for the executor to also be a beneficiary, not at all.
No, it's quite common. And look, to be really honest, I think that most of them are. And I'm in fact in favour of that, because I would have thought that the person who's most interested in giving effect to the will is the person who's going to get paid at the end. But the court said in this particular case that the way the defendant ran the case shouldn't impact adversely on the benefits that other beneficiaries get.
Well, it's a good reminder to do the job properly. 1300 222 774. Joanne in Surrey Hills is first up this morning. Hi, Joanne.
Hello. I am ringing on behalf of my sister. She was contacted a few weeks ago by the company she used to work for, a multinational, saying, look, there's been a glitch in our system. We've inadvertently been paying you for 6 months. You got to pay it back. It was $21,000. I don't know how she didn't notice. Anyway, that's... but, so installment...
She must have more money than sense, then, Joanne. Yep.
You said that, David, not me. But anyway...
It's the cause family problems here, David.
Yeah, exactly. And so they just... look, of course, she went into abject terror, and I've got to pay it back and I don't have it. What will I do? And I just felt that they're abrogating responsibility or putting it completely onto her and pay it now. $5,000 a week for the next 4 weeks. So where does she stand?
She has an obligation to repay. But because, the money's paid under a mistake, you're entitled to the money back. But the $21,000 that she's been overpaid has been shared by the employer with the tax office. So she won't have netted $21,000. There will be a tax attached to that. So clearly the tax component needs to come back, and they need to... It starts to get really gorgeously messy, because they need to give her a payment summary, the one you get at the end of the financial year, that backs out the overpayment. Because otherwise she'll be paying tax on the $21,000 as income. So they need to reverse that out of that, so give her a negative pay, if you like. And then what I would say is that, well, look, let's reach an arrangement in relation to the first bit, which is the in-pocket element, and I don't know what your sister's ability to pay is. But for the other part, you've really got to wait till I lodge my tax return and get a refund.
Okay. So, and if there are extenuating circumstances and it's quite difficult for her at the moment, can she negotiate something like, I'll pay you $10 a week for the next, 10 years or whatever it would be? No.
She can start that as an opening gambit. But I suppose if I was the employer, I'd want to know, why is it $10 a week if I've been paying you $1,000 a week for 6 months? Where did the money go? I know COVID-19 adds an extra layer of complication to that.
Indeed.
But I would have thought that if they commence proceedings against your sister, they could recover the $21,000.
Yeah.
So I split the two, will you? I mean, clearly if they give her a negative pay and they back out the tax element, then she's going to get that tax element back as a refund when she lodges her income tax return.
Joanne, we'll leave it there and good luck. Did she end up with anything special that she ended up owning because of this significant overpay?
No. I mean, I can't understand it. No, look,
where the money goes, it goes.
Her new job, I think she thought was particularly generous. I don't know.
Well, you're being a good sister intervening on her behalf. Good luck.
Thank you.
Thanks for calling in. Stephen's calling from Cheltenham. Good morning.
G'day, Virginia, and good morning, David.
Morning.
David, we've a problem whereby we inhabit a village here, a veterans village here in Cheltenham. The owner of the village, the RSL, has decided that it's going to sell it, and we're looking to take...
Is this a discussion is this a Vasey village that was discussed the other day with Virginia?
It is indeed, David.
Right,
yes.
okay.
Okay. All right. That just proves
sorry
I'm a
about that.
listener,
I was
Virginia.
trying to,
Good on you, David.
I was trying to slip that one in under the radar, but never mind.
Mm-hmm.
Look, as you'd appreciate, we're not terribly happy about this, and so are a lot of other people. Now, what we thought to do was to make representations to the people who own Vasey RSL Care Limited, which is a registered charity. Now, we are told that there are 22 members, what otherwise might be called owners or shareholders, in the charity. Now, mysteriously, the Australian Charities and Not-for-Profits Commission can't supply those details. The ACCC can't supply those details. So we have been advised that we should write to Vasey RSL Care Limited and say who actually owns the place.
Okay, Stephen, all right, I'm going to leave it there. We'll get some quick advice from David, because we've had a good go at this issue and many other people are waiting with their own particular legal problems. So, David, what's a quick answer to that?
You write to the Secretary and you ask for a list of the members. And you can also do a search on the ASIC website, asic.gov.au. They will have had a constitution before they joined the Charities and Not-for-Profits Commission, and you'll be able to get you won't get a list of the members, but you'll get a list of their rules and the process. They're covered by the Corporations Act.
All right.
So that's where I would start, Stephen.
Good luck. We're staying on the Vasey issue as well, so we can give that further airspace elsewhere. A quick question on text, David. I think we actually dealt with this the other day, but I think it was actually a change that's been made recently. It's just updated, but here we go. Pam asks, I'm a real estate agent in Victoria and I need to know, do I have to disclose a death in a property I'm selling?
The expectation is yes. There's one case in New South Wales which says yes. The rules changed on the 1st of April. Prior to the 1st of April, it was an offence to fraudulently conceal something that a buyer might want to know. Now you're required to provide whatever information a buyer might reasonably want to know. Now that the difficulty with the legislation is it relates to the buyer that you're talking to, not buyers generally. So consider, if you were buying a house, what would you want to know? Would you want to know if somebody had died? Would you want to know if there was a murder in the property?
Yes.
I had this very question from a client yesterday. They've sold a property and the oven doesn't work. Now, I would have thought that if you've got an oven in the kitchen, there's an expectation that it works.
Yep.
So their question to me was, she didn't test the oven, do we have to tell her? And my view would be, well, based on this particular provision in the Sale of Land Act from April, there's an expectation that what you see works.
All right, let's hear from Brian in Bayswater. Good morning.
Good day, folks. I rang a few weeks ago about the neighbour's pipe running through my property.
Oh, yes.
Who did?
Body Corp came back and said, look, Brian, that doesn't fall under the so-called common ground. That's your problem. The easement. Is that correct?
I haven't seen your plan of subdivision, Brian, and what you're telling me is that the area where the easement is, it goes under your unit and doesn't go under the owner's corporation. Is that right?
Yes, it's on the boundary.
Okay. Brian, have a look at the plan of subdivision. My view is that you're at the point where you need to get some real advice rather than 2 minutes every 3 weeks. And have a look at the plan of subdivision, because there's every chance that your unit will be defined in 3 dimensions. So it will have an upper limit and a lower limit as well as sides. And it may be that your lower limit is 1 metre below the ground. And if it is, then everything under that belongs to the owner's corporation.
Okay.
So that's spend the money.
Yeah, spend the money. You'll have to, at this stage, go and get some. So I was about to say decent legal advice. That's not kind to you, David, is it? That's not what I mean. What I mean is,
I know that's a fair assessment, Virginia. I'll go with that.
Let me rephrase: paid legal advice. Jenny in Mulgrave. Good morning.
Oh, good morning, David. Can you write an effective will yourself, or do you have to pay a solicitor? Or is there a government document which I can access where I could write my own will? And also, knowing that my will would most likely be contested, how do I write an effective will myself, knowing that it would stand in time? Thank you, David.
Right. So yes, no, and that's hard.
Yes, no, and hard.
No,
Great,
and
thank
hard.
you.
So
Okay,
you are entitled to write your own will. Absolutely. You do not need to pay a lawyer. There are legal kits that you can buy from a newsagent. There is an organisation called Legal Kits of Victoria, which you can Google. They have a will kit, and you can have a look online at thelawhandbook.net.au, and in the section relating to wills, there is a pro forma or template will. So that gives you the resources that you need. If you are preparing a will, then you need to think about who the problem that most people do when they draw their own will is that they forget to deal with the whole of their estate. So I'm giving my house to Fred, my car to Mary, and this is the end of my will, but it doesn't deal then with the money in the bank accounts and anything else that you might have. So make sure that whatever will you choose to do, if you do it yourself, encompasses everything. You know your will is going to be subject to a fight, then what you need to do is make sure that your executor is fully and properly armed with the reasons why that you have excluded or made the allocations that you have. So I'm cutting out my son or my daughter. This is exactly why. All right, now, then what you do is that you then add a note with your will every 12 months or so, and you say that I've reviewed and reflected upon the will I made in 2020, and I haven't changed my mind. I'm still not leaving anything to X, because quite often you'll get the assertion made by a claimant that Jenny and I became reconciled, and so therefore she promised to include me back in the will. Does that help?
Thank you, David. Are there specific lawyers that I go to write my will, or do I just go to the local lawyer down the road?
Most lawyers are more than capable of writing most wills. I know that's a bit glib. If you have a very complicated, if you have what I would call a straightforward will, then my view is that probably 90% of the lawyers in Victoria will do a really good job at it. The people who make long and complicated wills generally have a lot of money that they're trying to protect.
And how much am I expected to pay?
I'm going to wrap you up because we've had quite a number of questions here. Has it largely answered your question?
Thank you very much, and good morning to you all.
No worries. Thanks for calling in this morning. Dee has called in from Warrnambool. Dee, good morning to you.
Good morning.
Go ahead.
Our daughter purchased a vehicle in 2013, and by 2018 the paintwork was starting to blister and bubble in spots over the vehicle and underneath the bonnet. Our daughter took the vehicle to a paintwork specialist in 2019, and he said that this was a well-known manufacturing fault in this particular vehicle. The industry knew about it. He said to take the vehicle to the manufacturer and negotiate with them for a new paint job. The manufacturer has admitted that there is a fault in the manufacturing, in the base undercoat thingies that they put on, and they said to our daughter that considering the age of the vehicle that the vehicle is now, that they'd pay for half the cost of the repaint, and my daughter would have to pay for the other half. Now, should we accept this, or should we pursue for the full cost to be covered? You know, what would be the most cost-effective, sensible way of going about this?
Interesting question. The car is completely and utterly out of warranty.
Yes, definitely.
Yes, right. So there's no warranty in the vehicle.
No.
And what we're now dealing with is a car that is 7 or 8 years old.
It's actually a 2010 model, but it was in good condition and low kilometres when she bought it. She saved up.
Okay, so she bought a second-hand vehicle that's now 10 years. I think the offer from the manufacturer at half is pretty good.
Okay.
Because if we went and got the new paint, your daughter ends up with a better car than she bought.
Well, the car she bought was in perfect condition. She paid $15,000 for it. She was a student.
Yep.
She worked and she saved up for it.
Yep.
But we want to be practical here. And the manufacturer has said, yes, they've admitted that there was a fault in the manufacturing. Overseas, they're paying the full costs of the cover of having it sorted. Here in Australia, they seem to be a little bit reticent.
Oh, well, then I would be going back and saying, well, if the manufacturer in wherever the car comes from is paying full, tell me why you won't.
Well, yes.
But I actually think that's a pretty good deal.
You think it's a good deal? Okay, that's what we wanted to find out. Thanks very much for that, David.
Thanks, Dee.
Good to hear. Good to hear finally of a good deal being offered, David. They don't normally get extracted without a great deal of work. Very unusual. Bob has called in from Whitehorse Council. Hi, Bob.
Hello, David and Virginia. It's about power of attorney. About 30 years ago, I went overseas and gave someone the power to access my money to pay bills that I was encountering overseas and so forth.
Mm-hmm.
On return, I neglected to address this situation, and I have a suspicion that it may still exist, and am I at a disadvantage? And how can I go about finding if one does exist?
So you're telling me you gave somebody a power of attorney, but you can't remember who?
I know who it is, and the relationship has fallen away, unfortunately.
All right. And so do you still have the same bank account?
No.
All right. Then the chances... the easiest way to make a power of attorney go away is to write a new one.
Yes.
There's a process in the law for revoking a power of attorney. I actually think it's too hard, but the Powers of Attorney Act basically says you need to go to the same degree of work in revoking a power of attorney as you do in creating one. But the same legislation also says that if you make a new power of attorney, it has the effect of revoking all the other ones.
Right.
Can I make the power of attorney to myself?
No, but what you could do is you could appoint your partner, your best friend, your power of attorney, and then revoke that power of attorney the next day. So the first one that you make to your best friend revokes the earlier one. But that doesn't, if you don't give notification to the 30-year-old attorney that you're revoking that person's power of attorney, the Act gives them protection for anything that they do in thinking that it's still valid.
I see.
So you're significantly better off than saying, dear Harry, I'm not sure if I gave you a power of attorney in 1990, but in the event that I did, would you please note that it's now revoked?
Fantastic. Thank you very much.
Thank you.
Thanks. It's a really useful thing to do as well. Even though the relationship's fallen away, David, you can nonetheless put that in writing and have that there and dated, and you know that it's been received.
Absolutely.
Yeah, and that's a crucial part of it, I should think. I've actually got another very quick... Can we make our power of attorney, our next power of attorney question, just a quick one here, Nicholas in Geelong. Is that okay?
Fast.
Good morning.
Yep.
Yeah. G'day, David and Virginia. Okay.
Just quickly.
Hypothetical situation. There's 3 children. 2 of them go overseas, take an Australian power of attorney, do it in total secrecy, and get 2 people from overseas who can't speak English to sign a power of attorney. First of all, does that power of attorney have legality if the witnesses could not read English? Secondly, were those 2 siblings required to inform the 3rd sibling that they were enacting a power of attorney? And then fourthly, if they then use that power of attorney on the death of one parent to seize hundreds of thousands of dollars worth of assets and a property that was in
Nicholas,
name.
This was not a quick
Nicholas,
one, David.
it is possible for a power of attorney executed in accordance with Australian form to be executed overseas. The witnesses do not. The expectation is that the power of attorney will accord with the law at the place where it's intended to be used. So, and it's not necessary if I was, let's say, I don't know, I don't speak Slovak. So if you were to do a power of attorney and ask me in Slovak and ask me to witness it, then I could witness it, because what I'm doing is witnessing that you put your signature on it.
Even if
So
take now.
the argument that you would run if you were upset by it, you would argue that there's no evidence that the person who signed the power of attorney had knowledge of what they were signing.
Right. Now, were they required?
I don't have much time here, but very quickly.
Were they required to inform the third sibling that they had enacted a power of attorney?
No.
Okay.
All right.
Bit of a mess there, but some nice advice, David. Thanks so much. We'll talk again next week.
Hopefully.
Hopefully.